Cook, and I am a SCORE counselor here in Canton. Before I hand it over to Gaia, I just want to throw a couple things out at you. Number one is you will be receiving a copy of the PowerPoint as well as the recording. If you have any questions through Gaia's presentation, she'll answer them as they come up. So we'll break in when she pauses. And there'll be a brief 4-question survey that we're going to send you in the idea that give us some feedback how we might make these better. So again, my name is Ed Cook. I am a Canton SCORE counselor. I retired back in 2012 from Frito-Lay. But SCORE is a national nonprofit organization that began back in 1964. Nationally, we have over 225 branches or chapters and over 11,000 counselors. Locally, we're funded by the Canton Community Foundation, the Greater Canton Chamber of Commerce, and through the federal government. So besides sponsoring workshops like this that will benefit small businesses, we counsel small businesses, and that's really what our forte is. So we counsel startup businesses, existing businesses that are having issues, and that's whether they're for-profit or nonprofit. Locally, we have about 47 counselors, and they each have a very diverse business skill set. I mean, we've got people that worked in marketing their entire careers, or in banking, or in insurance, human resources. So, as whatever need you might have, we kind of call on those specific counselors to help you. So again, it's free and it's confidential. Locally, we cover a 5-county area, and Stark and Tuscarawas are the two biggest. Our office is located in Jackson Township at their administrative building. But our counseling will come to you we'll kind of work out the best time and best location. We can do it in person, we can do it virtually, whatever suits your fancy, so to speak. You can see our contact information on the screen now, and a QR code. So with that, I'm going to turn it over to our presenter, and that's Gaia Casatli. Gaia, it's all yours.
Thank you, Ed. Thank you very much. Hi, everyone. First, I want to thank you all for taking the time to join this webinar today. I know when you hear the words Contract 101, it's not the most exciting topic, but it is probably one of the most important topics in law. But before we get started, let me tell you a little bit about myself. If you're not familiar with me, I am Gaia Casatli, the founder and managing attorney at GK Law Co., which is a startup law firm and intellectual property law firm. I put my contact information there for you. Please use me as a resource. I did get my start in business with SCORE, so I'm a huge fan and advocate for them, and I do whatever I can to give back to other entrepreneurs through this wonderful organization. So that's my direct email address. You can also schedule a meeting with me through my website, gklawco.com. So I have been working with startups for a few years now. I've worked with several hundreds, and a lot of what I do is counsel startups through legal considerations. And what I found is quite a bit of what I do is contracts related, drafting contracts, reviewing contracts, and enforcing contracts. Today, I will be giving you a very high overview of contracts, but we can certainly deep dive. Please feel free to ask me questions. And at the end, when you take the survey, if there are topics that we discussed today that you'd like to know more about, please let us know, and perhaps we will hold another workshop. So on today's agenda, we're going to start with an introduction. We'll talk about what is a legally enforceable contract. Legally enforceable being the operative terms here, because not all contracts are enforceable. How to write a good contract, how to review a contract before you sign it, specific key considerations in that regards, and an overview on non-disclosure agreements. And then of course, we'll open the floor up to some Q&As. But like Ed said, if you do have a question as I'm going through this presentation, please raise your hand and ask it. I'd love to, and I'm happy to answer it as we go through so that you don't forget your thought. And I also believe that someone else might benefit from your question. So please do that. Now, the reason I keep saying over and over that this is an overview is because in law school, for example, contracts law is a 2-semester course, meaning a whole year. It is very complicated. And so this is an overview for that reason. So welcome to Contracts 101. Today, we're going to learn the basics of contract drafting and review with an attorney. Hello, that's me. And we're going to follow along to create a legally binding agreement like a pro. Please stick around to the end because I have something exciting to give away to you all, and also some good tips and tricks about NDAs that you'll want to know at the end. All right, so before I get too into it, first you need to know that contracts are governed by common law and the UCC, Uniform Commercial Code. Which type of law governs your contract depends on what you're offering. If it's a good, it's by the UCC. If it's a service, it's common law. And that's important to know because for it to be legally binding, it has to meet certain requirements. And that's mostly on the UCC end. So there's certain terms that have to be included in the contract for it to have some weight in the UCC. So whenever you're selling goods, just keep that in mind. You want to consult an attorney or do a nice search of your own of what the UCC is going to require. So what is a contract? A contract is a legally binding agreement between 2 or more parties. It outlines the terms and conditions of the agreement and protects all parties involved. This last sentence I have in here in that first paragraph, always get it in writing. Please write that down, star it, bold it, underline it. Please always get it in writing. And like I said, they're governed by common law and UCC. So why am I stressing to always get it in writing? So in my practice, I also litigate in the form of enforcing agreements, enforcing contracts between parties. And unilaterally at this point, all litigation has had to do with verbal agreements. You see, the thing is, if you are in a good mood and you're making these business deals with other people and they're in a good mood, it's really easy to promise something and for someone else to quickly accept it without truly sitting down and thinking about material terms that need to go in a contract or things that can go wrong. So here's an example. I represent a cleaning company that was based out of Cleveland, and they made a verbal agreement with a development company. This company was developing an entire apartment complex, and they hired the cleaning company to do post-construction cleaning. Well, when this agreement finished, when all the cleaning was complete, my client, the cleaning company, came to me because they felt like they were not paid the amount that was agreed upon. And the discrepancy was in the details that should have been in the contract. The size of the windows, whether the cleaning included the windows, whether it included the appliances, whether it included touch-ups after the fact. So those are the kind of things that when you're making a quick agreement, like, hey, I agree to clean your post-construction apartments, and yes, we agree to hire you. There's so many little details therein that are not included, right? So, oh, by the way, I'm going to charge you a premium for large windows or to scrape paint off the floors. So those are the type of things that became a huge issue. And we're talking about thousands, tens of thousands at stake. So this is why I stress always get it in writing. This is one example of many. And besides that, your writing should be solid, right? A contract has to include these elements right here. So your writing needs to include these for it to be enforceable in the first place. Now, when you think about an attorney, really, we're kind of Debbie Downers. Our entire job is to protect you from risk. So our mind goes to worst case scenarios. And so with that being said, whenever we are writing a contract for you, or reviewing a contract for you, not only are we making sure that the contract is legally enforceable, so it includes these elements, we're also thinking worst case scenario. What are all the things that could go wrong? Because we're going to assume they will go wrong. And how do we protect you proactively so that you don't have to worry on the back end? So you'll see a little bit more about that as I go along. But first, you need to understand what has to be in every contract for it to be enforceable. This is primarily under common law. The UCC has a few other requirements. For example, the UCC, in addition to these requirements, will require certain material terms be in the contract, such as the quantity of the goods, the price, delivery dates, and so on. So there are some additional requirements with the UCC. Right now, we'll stick to common law as that is more general and standard, okay? Offer and acceptance is the first thing. There has to be an offer. Someone has to have the intention. Intent is very big in contract law. The intention to make an offer to someone else, okay? So I am offering you to pay you to do something for me. And the other party who that message is being directed to has to accept. Acceptance can be made in many ways, and offers can be made in many ways. An offer could be, for example, on a very easy level. It could be I say something to you, I write it in you, and I in a contract, and I say this is my offer. Please sign on the dotted line if you accept. An offer could also be an ad on TV, right? The first 10 callers get something. Okay, so an offer could be like that as well. Acceptance can get complicated as well. Acceptance, like I said, could be saying, yes, I agree, signing on the dotted line. Or it could also be performance. If I offer you to paint my house for $100 and then you show up with a gallon of paint and start painting my house, you accepted my offer. So performance is considered a form of acceptance as well. Consideration is probably by far the most confusing part of contracts. A consideration is you getting something of value in return to the performance that you're being contracted to do. So the legal jargon we use is a benefit detriment, right? So there is a benefit in exchange for a detriment. On a very simple level, it's money. Most of the time it's money, but it could also look like equity. It could look like refraining from doing something you have the legal right to do. For example, you are 21 years old and your aunt says, you know, I really want you to do well in school. If you refrain from drinking alcohol this entire year of college, I will pay your tuition. There is an argument that that is consideration because you are giving up a legal right of yours. So consideration comes in many different forms. What is valuable consideration could be up for interpretation. I think sometimes you guys may be aware of the fact that people will sell, for example, a house for $1. And there's a lot of at least I'm very hesitant to allow that or include it in my agreements because there is a huge argument to say that's really not appropriate value, if at all, and that this was not intended. Remember, intent is a big part of contract law. It was not intended to act as consideration. Obviously, it wasn't $1 for a house. So consideration is a hot topic. If you are not someone who wants to go the traditional route and just do money, compensation as consideration, it's probably in your best interest to consult with an attorney or do a very deep search online of what constitutes consideration. And of course, you need to have competent parties, right? Lack of capacity is actually a defense to contract formation. And so what that means is the parties who entered into the agreement were not competent enough to do so. This looks like infants, very young people. I don't want to say minors. There are certain situations where minors, those being under the age of 18, are competent parties. In that situation, a contract would be enforceable, but it's voidable. So the age is a consideration, mental capacity, and then intoxication are also relevant here. So competent parties. Competent does not mean business savvy. It does not mean intelligent per se. It just means that you are of sound mind to enter into a contract and to understand the legal implications of the deal that you're making. So remember these 4 essential elements of a contract. Does anyone have any questions about these elements, or could someone maybe share an experience that they've been in that perhaps they ended up stuck in a contract that they didn't intend to make, or perhaps they had the intention to make a contract that wasn't understood as such by the other side? Any experience shared? I'll give you a few minutes to see if we have anyone who wants to bravely volunteer. Or maybe anyone's child who's entered into a contract. That would be a good story.
Yeah, we can unmute individuals, or I think you can unmute yourself, or you can put it in the chat, or whatever, however you'd like to give us answer the questions. If you have the raise hand feature, we could use it to unmute you. So.
All right, well, if you guys think of something, please let me know, but these are very essential, and so keep that in mind. All right, moving on. So we're going to start with drafting the contract. So in some situations, I think especially when you're starting your business, a lot of times business owners will use templates, which is a fantastic start. So if you are one of those individuals who's using a template, please keep in mind what I'm going to be discussing now to make sure that that's included in your template. So as I've shared, a valid contract has to have offer, acceptance, consideration, mutual agreement, which is basically an offer and acceptance, and then the mental capacity or legal capacity to enter in the contract. What you want to make sure is that when you're drafting a contract is that you're using clear language, defined terms, and that you are being super specific. If you're in doubt, seek legal advice, of course. So what do I mean by clear language, defined terms, and being specific? Defined terms, I won't touch on that too much. And clear language, I think that's self-explanatory, but being specific, when you are making a deal with someone, you want to be very specific what you are delivering to them, what comes with it, what warranties you're giving. For example, what happens if you don't deliver or they don't deliver, if there's no performance, so on and so forth. I'm going to go through these considerations in the next couple of slides, but I just want you to know that the name of the game is to be specific. If you're entering into a very high risk contract, what I always suggest to clients to do is to first start with a letter of intent, which is a letter between the parties that they agree on that discusses the material terms as specifically as possible. Here are my intentions, here are yours. Can we agree on those before we put all of this in a long contract for everyone to sign? So specificity is really key to a good contract. Otherwise, you might as well just do a verbal agreement if you're not going to be specific. Is there a question in the chat, Ed? I see a little one that just popped up. Amber, can I also get the slides emailed to me? Yes, absolutely. At the end of this presentation, we will be circulating a survey, but you will also all get a copy of this presentation to have for your records. Oops, let me go back.
I think she's looking for a hard copy. I could be wrong, but I'm not sure we're set up to send a hard copy to anybody. Amber, can you chime in?
Amber, whenever you get a second, just clarify if you're talking about a hard copy, but you will all be receiving this presentation in a PDF form. All right. So let's talk about actually writing the contract. Here's the tips I have for you. Believe it or not, the first tip I'm going to go with is formatting. In Ohio, at least, and I believe in a lot of other states as well, courts are, and let me clarify, common law is basically the law of that state. It's like just what is common in that state. So I'm going to talk specifically about Ohio. Different states have different views, but in Ohio, our judges and courts like to interpret the contract as it is within the four corners. It's called the four corner approach. And in order to be able to interpret a contract appropriately, and for the judge and the jury to understand what your intentions are, it's my belief that you need to have really good formatting. You need to make it so that your contract is easy to follow and easy to understand. For example, you do not want to talk about the services that are contracted to be delivered on page 1 and on page 3. It's confusing. It's hard for someone to understand your intention there. So what I do and what I found to be super helpful is to use this following formatting whenever you are drafting a contract. And trust me when I tell you, this makes all the difference. The first thing is you want to start with a header. This is not required legally, of course not, but it really does set the tone for your contract. A header is just a descriptive title. What can someone throw out there what type of business they're in? Are you a life coach, for example, or an attorney, or a psychiatrist, or do you have books that you sell? Someone throw in there what type of business you're in. Videography, Terry Banks. Okay, so videography. So this is going to sound super simple, but it makes a difference. So your descriptive title could be something like videography service agreement. Boom, straight to the point. But it really sets the tone because it tells people, or maybe perhaps production service agreement, it tells people on a high level what we're going to get ready to talk about, what our intention here. It sets the theme for the contract. Next is the opening paragraph. Please do not skimp on this. This is important. And the opening paragraph is where you clearly identify the parties involved and their roles. So what you have to think about is as your business is scaling, as you're getting more and more contracts, you're going to be dealing with a lot of people, right? It becomes very volume intensive. And in that moment, you know who you are dealing with, you know who that individual is, you have their name in the contracts, perhaps their business name in the contract. But let's say something goes wrong and you want to sue them. And let's say their name is John Smith or ABC LLC. You need to serve them the complaint, the lawsuit. How do you find them? If there's a dispute, do you think you're going to send them an email and say, hey, can I please have your address so I can sue you? Do you think that they're going to be responsive to you? Or if you want to sue their company and their company wants to avoid a lawsuit, do you think they're going to make it easy for you to find them? The chances are probably not. When there's a lot of tension involved, people are not going to be really receptive or communicative with you. And so it's really important to have an opening paragraph that identifies the parties and where they're located. If you're doing business as a business, so B2B, business to another business, what you need to do is have your formal business name and the other party's formal business name, the type of entity they are, and their location, where they're registered at. You want to know where they're registered because then you can go to that Secretary of State's website and you can find out who their statutory agent is so that you can serve them any type of paperwork that you need to, legal paperwork. A statutory agent is not the owner of a company. It's not necessarily the representative or decision maker of a company. It's just someone who's designated by law to accept documents, legal documents on behalf of the company and give it to a decision maker. So there's a lot of statutory service agencies out there that you can pay around $100 a year to act as your statutory agent. But to be able to even find that person, you need to know what state that company is registered in. So an example of an opening paragraph is the name of my company is GK Law Co. That's my DBA is GK Law LLC. So what that would look like is this agreement is made by and between GK Law LLC, an Ohio limited liability company. If you'd like, you can also include with its principal place of business at 800 North High Street or whatever, and put the other name of the LLC, ABC Inc., a Delaware corporation located at with its principal place of business at, etc. If it's between parties, you want to do basically the same thing. This is between John Smith, located at, put the address there. This is super important. Please do not forget this. And really, the reason is to identify who that individual is. Next, you want to move on to your operative provisions. This is where you specify those details we were talking about in the previous slide, right? As much details as you can include. I know that a lot of small business owners do not enjoy long contracts, and they do not enjoy contracts with a lot of legal jargon, and I can respect that. Those type of contracts do come off very intimidating. But what I'm going through now does not have to be intimidating. You can use very simple terms, very straightforward and clear terms when you're drafting all of this. It's just the type of details that you need to make sure to include. So, operative provisions. This is where you specify the terms and conditions for things like payment, the delivery of the goods and services, liability limitations, any waivers, cancellation policy, IP assignment, and so much more. Let me talk to you a little bit about liability limitations and why this is important to put in your operative provisions. So, like I said, things can go wrong in a contract. This is what we anticipate, what we expect. If things did not go wrong, there's no need to have a contract in the first place. We would just do things on a quick handshake. A liability limitation is anticipating that. It's saying, here's the services we agree to deliver to you, and here's how much you agree to pay. But sometimes things go wrong outside of your control. And I would love to hear from you if this has ever happened to you. But things can go wrong. Like, for example, you're working with a third party that fails to deliver. So I believe it's Terry with the video production company. Let's say that you have hired editors to edit these videos that you shot, and the editors are late on something. And so you miss a deadline, and that deadline causes some material damage to your client. And it wasn't necessarily your fault. We can talk a little bit more about indemnity provisions in the boilerplates, which is where that third party would be required to cover all of your legal fees and damages that you incurred as a result of their breach. But in that situation, a liability cap would essentially make it so that your liability is capped at a certain amount. So for example, I have a client that I work with who had a very similar situation happen. They deliver a good in scale, so quite a bit. And their manufacturer did not deliver on time. So then their delivery to their client did not make it on time. And it caused quite a bit of damage. And in that situation, their liability was capped at about $100,000. But true damages was well beyond that. And so we were able to enforce that cap of $100,000 and not pay more. And, you know, my client saved hundreds of thousands in that situation. I know that me saying this probably does not feel very good to you all, because you're saying, oh my gosh, they caused all this damage. Why wouldn't they pay all of it? But the truth is, we all have the freedom to contract and to negotiate. Every single contract out there is negotiable. There's a lot of vendors out there. You have options. That's the beauty of the world that we live in. And so whenever you're entering into a contract, these are the type of things that you truly need to anticipate and make the cap so that it's appropriate. But in this situation, both parties agreed on the limited liability cap, and that cap was mutual, meaning it benefited both parties. It just so happened in that situation, my client benefited from it, but it could have been the other way around as well. So this is important because it really could save you a lot of money later on and headache to include these type of things. And this is what you would want to put in your operative provisions. IP assignment is intellectual property. Do you all know what intellectual property is? Raise of hands if you do. I actually cannot see your hands. I'm going to assume there are some hands that are up. But intellectual property is basically your trademarks, copyright, trade secrets, and your patents. And IP assignment is important to also include in your operative provisions, because this is another specific term that we're talking about. This basically lets people know that, you know, if I'm hiring you, videographer, for example, to shoot this content for me, you do not own it, I own it. So it discusses who's the rightful owner of the intellectual property that is subject to the agreement. And we do an IP webinar as well. Believe it or not, a lot of the things that you do could in some ways qualify as intellectual property. So these are the type of things that you want to include that you really don't think about, but that are important and could have some future implications. So operative provision. Moving on is the remedial provisions. So you can kind of see the flow here. We have your header, the intro, the opening paragraph, who it's between, what is being contracted in specificity, the term, how long the contract is for, so on and so forth. And then we have the remedial provisions. What happens if someone breaches the contract? We include dispute resolution clauses here. For example, arbitration or mediation, or we just take it to court. You know, these are the type of things that we include here, dispute resolution. Perhaps we include any type of fees that are going to be charged, anything like that. So remedial provisions will go next. I'm a huge fan of including arbitration and mediation clauses before lawsuits. And so basically what that means is if there is a dispute, naturally what happens is that the parties will try to talk it out. So I deal with this quite often with my clients too. You talk to the other side and say, I can't believe you did this. I can't believe you did that. Here's what you need to do to make it right. And usually when you're angry, what you're asking the other party to do is probably pretty out there, and the party is not going to want to do it. So then you do a dispute resolution saying, before you sue me, and when you get sued, it becomes public record. And, you know, there's some argument to say it could ruin your reputation as a small business owner. You don't want to be that business owner who's constantly suing their clients for example, non-payment, which would be a big one. So you would say, instead of you suing me, you have to go through mediation first. A lot of small business claims courts will have volunteer mediators. I used to be one for a few years. I think I did it for about 2.5 years at Akron Municipal Court and or at Summit County. And basically you would go into a room with the two parties in the agreement, and then you'd have a neutral mediator that helps you talk things out and agree to something. Whatever resolution you agreed to, you would write it down, sign, and that's what you would do. If you cannot agree, then you can move forward with your lawsuit. In Akron, it is mandatory. Some states or some counties it is, some counties it's not. Alternatively, you can do arbitration. Arbitration is binding as opposed to mediation, which is not. Binding meaning that once you go through arbitration, you have to go with whatever is decided. And the difference is arbitration, you would present very similar to a case where you'd have your attorney with you, you'd have evidence, exhibits, both people would tell their side. And then you have a panel that's usually made up of attorneys or judges, about 3 people, and they would hear your case and then they would come up with a decision. And this is all private, which is nice. So whatever decision they come up with would be the binding one. And then if you do not want arbitration, for example, naturally you can just go forward with a lawsuit that you would file with your court, with the appropriate court. Finally, or not finally, the last 3 is the closing or boilerplates. And I'll talk to you in the next slide about what the boilerplates are. A lot of small business owners I found are really hesitant to put these boilerplates in. They just want to close the deal. The boilerplates do make it feel a little bit more intimidating. It's a lot of legal jargon in there, as you'll see in a minute. But boilerplates are there for a reason. These are all clauses or provisions that attorneys included in contracts based off of case law, meaning someone was sued, this wasn't included, it hurt their client, they learned their lesson and they added it in the contract. So boilerplates are necessary, and they can be reduced down to 1 or 2 sentences, and they could be written in a manner that is not intimidating. So boilerplates are necessary. Don't get kind of caught up with how long or intimidating they are. They could really be summarized to very short pieces, but please do consider including them in your contract. And I'll talk more about them, like I said. You have your signature line. This is also important. A huge consideration for you all in your signature line is to make sure that all contracts you're entering into are on behalf of your business, so small business owners, on behalf of your business and the other party, not you individually, unless you're a sole proprietor. But we do a segment about entity selection if you're interested in that, and we heavily recommend that you're an LLC in most situations. Basically, the purpose being limiting liability to you personally, right? So limiting exposure of your personal assets in case your business breaches something or owes some kind of debt. So your signature line has to reflect that. Otherwise, what will happen is the other party will try to come after you individually, right? That theory is called piercing the corporate veil, where someone is like, I didn't contract with the company that perhaps has no assets and I cannot collect from them. I contracted with the individual, John Smith, who has deep pockets. John owns a house, he has a car, he has a checking account and a saving account, he has stocks, he has a lot of liquid assets that I can take, basically. So you want to make sure your signature line represents the fact that it is your business that enters into the contract. It's also important if you're entering into a contract with a minor that the signature line is made between an authorized representative, perhaps the parent, because otherwise the contract is voidable. But if it's with the parent, then it's enforceable. So signature line would look something like this. GK Law LLC, or let's just say the line, the signature line, my name, Gaia Kisatli, my title showing that I have the authority to bind my company or enter into an agreement. So CEO, for example, or as an LLC member, and then the name of the company, GK Law LLC. Last but not least is your extra stuff. This is your attachments, your exhibits. So sometimes if you have a very long schedule of services that you are going to be offering, like the video production, if you're like step 1 is the shoot, then the editing, and then I don't really know what goes into video shoots, but I know I can imagine in creative industries, it's quite a bit of a schedule. You would include that as an attachment so that you're not taking up too much space in the body of the paragraph. So you'd say something like, you know, this person, Terry, agrees to offer the services outlined in attachment A, attached here to and incorporated herein by reference. And so we'd go to attachment A at the very bottom, or schedule A, or exhibit A, whatever you want to call it. And then we can see there what your deliverables are. All right. Any questions about that so far? Do you guys have any questions about the formatting, opening paragraph, operative provisions, boilerplates, anything like that that I can answer for you before we move on? Social media content. Yes.
Looks like you have a question from Terry. I have a contract, but does not include a mediation resolution clause. Do I need to add it?
How do I get it added? So this is great. Is your contract, Terry, is your contract already signed and executed, or you're talking about just kind of like your standard contract that you send out?
I think you can unmute yourself if you want, Terry. Standard, okay.
Standard, okay. Just go in and edit it. Just literally go in and edit. You can Google a mediation provision, contract provision or clause, and I would just copy and paste a version of that into your contract to call for mandatory mediation. And I'm a fan of mediation. It's not binding, you know, but it's a great way to get the parties to talk and have someone kind of calm the room down. You are welcome. Linda, social media content developer and manager. Very cool. Very cool. Thank you. I think you're answering my question from earlier where I was asking about the type of businesses you own. So I'll definitely use you as an example as well. All right, so next tips for writing a contract are these boilerplates. Please bear with me on these. I know these are going to be a little bit dry. If you have questions, I encourage you to ask them. The reason that I wanted to talk about boilerplates is because I really want you to understand what they are. So when you read them in a contract or when you're drafting a contract, that you understand whether they make sense to include for your business and whether these are things that you need to negotiate out or adjust in someone else's contract. So the first step is to understand what they even are. We have waivers, force majeure, assignment, relationship of the parties, governing law, submission to jurisdiction, notices, severability, survival, amendment and modifications, headings, and complete agreement. A waiver is basically saying if you as a business owner or not, I keep going to business owner because I believe that's the nature of everyone on this call being going through SCORE, that you are all prospective business owners or current business owners. But a waiver is essentially if you decide to waive a certain obligation that you have under the contract. This provision says, just because I waived one provision doesn't mean I waive everything else. So this is what that says. Force majeure. I'd like to know, a quick question for you all. Did you operate your business during COVID? Was anyone in business during COVID? And I'm curious if anyone can just share an experience on whether COVID impacted their business in any way. Specifically, were any contracts that you were part of, whether you're required to fulfill an obligation or someone else was, where it could not have been fulfilled because of COVID? We had a crazy pandemic. So any interruptions in your business on that regard, please share your experience, or even if you want to just drop your answer in the chat or raise your hand, I'd love to hear more. I don't see anything in the chat. I'm not sure if hands are raised. Ed, can you see any hands?
No, I'm seeing no questions. Oh, there we got a chat from Terry.
Let's see. I was not in business at the time, but as a videographer, I would have been impacted. You definitely would have been, Terry. A lot of people in the service industry were very heavily impacted. What happens in the situation where there's an act of God, which is what we typically say in law, an act of God that happens that makes it impossible for you to do what you contracted to do? For example, in Terry's situation, oh, I'm sorry, did someone say something?
Not seeing anything here.
Okay, so in Terry's situation where you're a videographer, you're required to be on site for things, and COVID-19 made it so we could not go anywhere. You were not allowed to, you know. In that situation, what do? His contract says, you know, I'm going to shoot this content for you by this date, and in exchange, you're going to pay me this much money. And his client paid that much money, but Terry could not be on site to shoot the content. What happens in that situation? Well, the force majeure clause comes into play. There's actually a lot of businesses that did not have this clause in during COVID, and there's quite a bit of litigation about breached contracts. I'm not quite sure what ended up resulting in each one of those litigations, and there's probably some good defenses as to why they would not have been enforceable in the first place. But essentially, in that situation where a lot of people were expecting money in exchange for a service and they were not getting paid for something, the force majeure clause would have helped quite a bit. This clause says, If there is an act of God, there's a fire that burns down my venue that you're supposed to have a wedding in, right? There's a global pandemic that makes it so that I cannot leave the house. If there's anything major like that, any natural disaster, any war, things that you really do not expect to happen, but believe it or not, do happen. And unfortunately, they do happen. In those situations, here's what we're going to do. The force majeure clause gives you some options. They say either one, your performance is excused and I will refund you what I can, but I do not have to perform under these circumstances. Or it can say, I will do my best to remedy the situation within 30 to 90 days. So it really basically gives the parties the opportunity to discuss what do we do in the situation that there is something outside of our control, which is why we call it an act of God. Very important to include. An assignment clause is saying that you agree to or disagree with the other party assigning their duties or obligations under the contract to another party. This is important if you're in the type of business that makes it necessary for you to perform, like someone is hiring you specifically as the expert. So if someone's contracting me as Gaia Kisatli because they believe I have the skill set that they need and they don't want another attorney at my law firm to do the job, they would want to say, you know, I want you specifically, you cannot assign your duties to someone else. You cannot assign this contract as a whole to another law firm. So assignment is basically that. Relationship of parties. Here I'm talking specifically about whether the person is your employee or an independent contractor. You traditionally, when I see these clauses, it's independent contractor, where we're saying that the parties in this contract who we identified in the opening paragraph, their relationship is of independent contractors and not employees or representatives of each other or anything else like that, or agency. And the reason being is that the liability that flows from an independent contractor to someone hiring the independent contractor is a lot less than an employee. Anything your employee does, with exception, is your responsibility. So if they do something that causes someone else to get hurt, that person comes after the company, not that individual employee. So if you slip and fall at McDonald's because an employee did not, wipe up the floor, you're not going to sue that employee. You're going to sue McDonald's. So it's very important to be clear on the relationship of the parties. An independent contractor, alternatively, is the one that would be held responsible in the situation, with limitations as always. Governing law, if I am located in Ohio, I'm doing business with someone located in California, which state is going to control the contract? And I'll tell you right now, Ohio laws are super different from California laws, which are different from Florida laws and some other states. Some laws can be similar, but for the most part, they would be different. For example, non-competes in California would not be binding. So if I put a non-compete in my contract and I say it's governed by California law, doesn't make sense. It's not going to be binding. I can't enforce it. So you'd want to say specifically which state's law governs that contract. Submission to jurisdiction is if I get sued or I want to sue, which jurisdiction, meaning which state or city or county, is the one that will hear this case. This is super important as well. For example, right now I have a case where the clients, they contracted and submitted to Florida jurisdiction. It's an Ohio client who did business with a Florida client, and they submitted to Florida jurisdiction. As their general counsel, I really wish I could just litigate this in Ohio because it's convenient. The client doesn't have to travel anywhere. They don't have to worry about finding another attorney that they do not know and have to rely on. They could just work with who they have. But in that situation, they submitted to Florida's jurisdiction. So that means even if we take the lawsuit in Ohio, it will very likely get dismissed for improper jurisdiction, and we would have to go to Florida and sue. Notices, a lot of the times your contracts will require notices to be given. Very easy one is if you want to cancel the contract, who do you tell? Who do you let know that I'm giving you notice, I'm canceling this contract. You told me I have to give you 14-day notice. Here's the notice. So your notice provision just outlines specifically who gets that notice. If you have a legal department, you would say, you know, with a copy to or forward to, but usually it's going to be you with your email address or your physical address if you prefer. Severability is saying if any part of this contract is deemed unenforceable for whatever reason, then it is severable from the rest of the contract. So I can still enforce the rest of the contract. For example, if part of my services are not enforceable, but the other parts are, it's not going to void my entire contract. We'll just sever that part out, but the rest is still binding. Survival is kind of along the same lines as saying that there's certain, well, sort of. A survival is saying there's certain provisions in your contract that will survive the expiration or the termination of the contract. I know that we're not talking too much right now, but I would like to hear what type of provisions do you all think should survive the expiration of a contract? So social media content creator, you create content, your client is super happy with it, they paid you, that contract is technically done. What provisions should outlast that contract? Anybody want to chime in? And I'll give you some hints. We talked a little bit about intellectual property earlier. So your certain rights to your branding, trademark, to your copyright. We've also talked about confidentiality. Anyone? Fear not, I have the answer for you. Fear not. What you'll find is the type of provisions that should outlast the contract are those protective covenants, right? And so those look like your confidentiality. Whenever you are in a contract with someone and you're doing business, you're going to have access to a lot of their private business documents. For example, their customer list. A customer list is trade secret and it has a lot of value. There's people who literally buy data out there, who buy it. Okay, by the way, data could be consideration, but anyways, confidentiality, non-competes. Those are the type of things that you definitely want to outlast the contract. And you'll see that. You'll see a non-compete lasting for a year from the termination of the agreement, plus a year, okay? Confidentiality, you probably want things to remain confidential in perpetuity and forever, or until you no longer have a business, or until it no longer has an impact on your business. These are the type of things that you want to make sure outlast the contract, and that you say that survival, they survive past the contract death or termination. Amendment and modification. Terry brought up a good point. How do I add the modification provision in my contract? And I asked, is the contract already executed? Did someone already sign it? If so, what you want to do is amend the contract or modify the contract. And you want to allocate that this is what needs to happen for the amendment or modification to be binding or to take place. Traditionally, what that looks like is a sentence that says any modifications to this contract have to be made by a signed writing by both parties. So if I am adding something to a contract or modifying a term in the contract, I cannot do that unilaterally. I cannot say, I actually want you to pay double that price. I'm gonna write this and sign it myself. You would need to agree, and you don't want to agree verbally. You'd want to agree in writing so we can make sure both parties are on the same page. So this is basically what that provision is. Your heading, I'm a fan of headings. I think that they help with the flow, that they help make clear what we're going to talk about next. But what this provision says, this boilerplate says, is that heading is not the provision. Don't take this heading and interpret it as my intention. The intention is written in the body of the paragraph underneath that heading. So obviously there's case law that justifies why that needed to happen. When you're angry and you're trying to enforce something, you're going to nit and pick and choose the type of things that you want to use to support your intent or your side of the story. And so things like the heading do come into play. Last but not least is complete agreement. Super important as well. Sometimes you'll have people make deals in many different platforms. Perhaps it's in your DMs, your direct messages on Instagram, a text message, a written contract that you just quickly put together, your letter of intent, all of these different things contemplating the same deal. You know, you're going through a negotiation process and you're contemplating the same deal. And then you finally put together this beautiful contract and you present it to the other party. The complete agreement provision in your boilerplate says everything else we talked about, all the verbal promises I made to you, all of the things that I text messaged you or put in your Instagram DMs or TikTok or whatever, all of those things are no longer part of this agreement. The only agreement is what you have in front of you, the four corners of this contract. This is what makes it the complete agreement, period. Super important, super important. And I will caution you as well. Make sure that what you sign is your complete agreement and it's specific. And if there's anything that you agree to or someone promises you outside of the contract, that you get that in writing, because it's not going to be enforceable. It's very difficult. And there's certain rules that you'll learn in contract law, such as the parole evidence rule and other rules of that nature that basically makes it so that there are like hoops and hurdles for you to get through to make any other agreements enforceable when you have a complete agreement. So you want to make sure that your agreement is the full manifestation of what you intended to be here. And the slide that I showed you before, right here, we talk about the different parts of the agreement. I would heavily follow that and even deep dive into operative and what type of terms should be included so that you can make sure what you have is actually a complete agreement. Because when you don't have that, that's when dispute arises, truly. Dispute arises when there's ambiguity on any topic. And when there's ambiguity, that means that specific intention is subject to interpretation. When it's subject to interpretation and the two parties that are in the contract cannot agree on it, this is when you bring in someone like a judge and jury to decide for you. Imagine that. Imagine someone who doesn't know your business, doesn't know your intention, doesn't understand the deal that you made, interpreting your contract for you and making you legally bound by their interpretation. Whew. I wouldn't want that. Sorry guys, but that was a really passionate moment for me. All right. Next, we're going to move on to reviewing the contract. So before I do that, does anyone have any questions about writing your contracts? That was quite a bit to take in. We talked about formatting, we talked about boilerplates, legal requirements so that your contract is actually binding. We talked briefly about common law versus UCC, meaning selling a good versus a service. Any questions so far that I could answer? And you will have an opportunity for Q&A at the end as well if you don't have questions right now.
Not seeing anything here, Gaia.
Okay, all right. All right, well, let's talk about reviewing the contract. This is another big part of my job as an attorney. I review contracts for you and I advise you to sign them or to negotiate certain terms that have significant implications on your business out. I will tell you that your risk tolerance is very appropriate when reviewing a contract. The type of deal is very appropriate to consider as well. And I say that because some deals are just too good to give up. Listen, I work with some clients who have enterprise clients, okay? So a marketing agency is one of my clients, and They have a huge enterprise client, a Fortune 500 company. And we've tried to negotiate a lot of these terms. So I'm talking about a very new LLC that just happened to amazingly land an enterprise client, and a huge enterprise client that's been around for many, many years. One person has more leverage than the other. One person needs the other person more. And so in those situations, you know, when you're reviewing a contract, you understand that perhaps there's some risk involved, but it's worth it. So I want you to keep that in mind, because what I'm going to be talking through with you is what I call overly lawyering a contract review. And that's a thing. But at the end of the day, you as a business owner, you have the autonomy, and it is really your job to make the decision of what type of risk level you're comfortable taking. Your attorney is your advisor. We advise you. But I will tell you, we will note the file that we advise you and you went against our advice at some point. But it is truly up to you of what risk level you choose to take. And that's okay. And it's totally okay. Okay, so reviewing the contract, when you do that, what you want to check for very high level is clear language, defined terms, that there's mutual agreement, that there's consideration and legal capacity. And of course, if you're not sure if those things exist, you want to consult with an attorney. A couple things to look out for more specifically is the details, like we said, especially when it comes to deadlines and payment terms. Believe it or not, even things like, besides how much is going to be paid, it's when it's due and how it's going to be paid. Are you going to write me a check? Are you going to pay by card? Do you have a grace period? I found, believe it or not, that a lot of these larger startups will do like a net 60, net 30. The enterprise clients do a net 90 days. So these are the type of things that you want to make sure you're comfortable with and you want to review. And this is when I'm reviewing a contract, these are the things that I'm asking you about and sharing with you. Of course, you want to make sure that it's clear and unambiguous. Like we said, if it's ambiguous, you open yourself up to someone else's interpretation, meaning litigation. You're taking it to court so the court can interpret it for you. You want to really understand the restrictive provisions, confidentiality, intellectual property, NDAs, non-competes. You want to make sure these work for your business. Imagine you as a videographer, or let's use a social. I'm trying to think if that would be a good example. If you're hired by I keep going to a law firm, but let's say a health tech company. If you're hired by a health tech company to run their social media campaigns and ads, and then, you know, you're a small business owner, you're in Columbus, Ohio, we have a pretty healthy health tech industry out here, and that agreement ends. You want to make sure that the contract that you're entered into, you remember the survival provisions like a non-compete outlive the contract. You want to make sure that you have the opportunity to work with other health tech companies, because in that year, you've refined your craft as a health tech social media agency. And you want to be able to work with other health tech companies in the very near future. So these are the type of things that you want to draw your eyes to understand your parameters during the agreement and after. And if it is a high risk or very complex contract, usually if it's a high dollar amount or a lot of services being provided or delivered, in those situations, it would be prudent to have an attorney or some sort of legal advisor take a look at that so that you can understand the true implications of that contract. Now, stick around, because towards the end, I'm going to give you a deep dive into NDAs. I hear about NDAs quite a bit from people, whether you're pitching your idea to someone or you are going to be hiring someone and you want to keep certain things confidential. And so I understand that they're very important and hot topics. So we'll talk a bit more about them here in the end. But there's other restrictive covenants that I would love for you to be aware of. Please jot these down. Please understand what they are. They are very different and enforced in very different ways, okay? The first one is a non-solicitation agreement. You know what, I'm sorry, I want to go back real quick because I think it's important for me to talk about, let me just go back here. I do want to talk to you guys kind of about the flow of contract reviews so that you understand. If you are someone who, even if you don't have an attorney or you do have an attorney and you're working with someone who has an attorney or does not have an attorney, there is a contract review and red line process that is pretty standard. So if you read a contract from a vendor, for example, and you don't agree with all the terms, so, you know, we're sitting here and saying, check this, check that, make sure that this is okay, make sure that's okay. Let's say you're in a situation where you decide, wait a minute, that is too restrictive. I cannot not compete with this company for 7 years. That's ridiculous. I need to redline this, meaning I need to edit this. And I need to make sure that the other party is okay with it. You can't just edit it and trick someone into signing it. That is going to most likely not be enforceable. You both have to have mutual assent, be on the same page. And so in that situation, we engage in what's called a red line process. This is done with attorneys. It could easily be done without attorneys. What you would do is you would take that contract and you would redline. So open up a Word document and click on that track edit pane or track changes and make the changes that you want, add comments that you want, save it with a new title. Perhaps it's the videography service agreement version 2, and you would put like GK comments, put the date and send it to the next person. And you would say, please see attached red lines. Can we discuss? Most likely that other person, especially attorneys, we just do a lot of things through writing. They would accept the changes they're comfortable with, or they would come back with other changes that are maybe more mutual to both parties, or they would just comment as to why they don't want to accept any of the changes and send it back to you. We do this, you know, back and forth ping pong game for a little bit until we're both happy with this agreement. And what I found is agreements that are not one-sided, that start out mutually beneficial, are usually quicker to get through these processes. So we do this ping pong. We finally say, this is good with me. This is good with me. We accept those changes and then it's executed. This is a contract review redline process that I encourage you all to partake of, especially if you have the leverage to. And this goes back to the point I made earlier. All contracts are negotiable. That's how you negotiate a contract. We keep it all in writing. Okay, let's go back to our restrictive covenants. I'm sure you've all seen these before. A non-solicitation agreement, when you see a non-solicitation provision, this is specifically saying that you or the other person cannot solicit your employees, your vendors, your clients, or the like. Certain industries make it so that it's enforceable. A solicitation is you inducing someone to do something. So you go up to an employee and say, hey, I'm getting ready to start my own company. You should come work with me. I'll pay you more. Cannot do that if you're bound by non-solicitation. Or the customer, hey, I'm going to get ready to start my own. Come be my customer. Sometimes you cannot do that if there's a non-solicitation. I will tell you, industry specific though, some industries do not allow you to bar solicitation, and some allow you to. So in the legal industry, for example, if I'm working at a big law firm or any law firm and I'm leaving, I cannot go and solicit the clients and say, hey, you should come with me, but I can let them know I'm leaving. So you can let people know you're leaving and that you're going to start your own thing, and just let it be at that. People have the freedom to contract. The market moves things. The market is what drives our society. So people are allowed to shop around, and that's okay. They can come to you on their own free will. You just cannot induce them. The same thing with employees. Okay, so solicitation is just that. You know, this is actually a great example to explain it. You ever been to a store and they have no solicitation sign? That just means do not come here and start passing out your business card. That's solicitation. but you can on a high level just talk about what you do. So there's confines, and I'm hesitant to give you too many examples because really it comes down to what you agree on. But what I usually do, if it's not a super detailed solicitation agreement, is I defer to like legal definitions of what solicitation means. All right, so that's what that means. IP assignments, intellectual property assignments, it's who owns the intellectual property. These are things to look out for. I see we have a question that just popped up, so let me pause here and answer that. Toy Bryant, can I get a copy of this video via email or text? Correct me if I'm wrong, but I believe that that is going to be a PDF. I don't think it's a video. Are we able to send a video by chance, Ed or Glenn?
I don't think so. I think we send everyone a copy of the PowerPoint and a recording, and I don't think it's a video recording, it's just audio.
Okay, so you'll get an audio then. All right. Let me.
It is video.
Oh, okay.
Okay, wasn't aware of that. Thanks, Gwen.
All right, let me just close this out. Okay, all right. So IP assignment, this is super important for the attendees here in the creative industry. A lot of what you do is intellectual property, and believe it or not, even if someone hires you to do it, at face value, just on its face, you own it, specifically in copyright. If you are the author and it's an original creative work, you own this, okay? However, if someone is hiring you to do it and they include a restrictive covenant that says something like, this is a work for hire, I own this property, and you agree to sign or do anything necessary to make it so that others know I own this property, you would be bound by that. So you want to look out for anything that constricts you is kind of the theme here. You want to look out for that. Confidentiality, it is the nature of contracts that, like I said before, you'll be exposed to a lot of confidential company information, whether it's customer list, trade secrets, things like that, that make the company, that gives it its competitive edge. Those are the type of things that you want to make sure make sense, that they remain confidential, and you want to understand that you are bound by these past the agreement. You need to know that, because if you don't know and you act improperly and someone sues you, you cannot claim ignorance. So I do look for that. Non-disclosure agreements, anything that confidential information, again, that you agree not to disclose, you want to look out for that. And the confines, how long it lasts, is it too restrictive? Is it not restrictive enough? And then non-compete agreements. I will tell you, if you see a non-compete agreement that is ridiculously restrictive, saying something like, you agree to not be a doctor in the entire city of Columbus, Ohio for 7 years, most likely that is not going to be enforceable. But non-competes are generally in Ohio enforceable. So you want to make sure that the confines, the parameters of that make sense to you, and that they're not going to disadvantage you as a business owner. The next PowerPoint, the next slide, we're going to be talking about NDAs, and then we're going to be wrapping up soon. So does anyone have questions about any of these other restrictive covenants before I move on?
Something in chat from Terry. As a hired videographer for a wedding or a retirement celebration, and I create an end product, would that product be my IP?
That would be your IP. I would need to see your contract and what it says about that. Sometimes in those contracts that I've seen, for like content producers like yourself, I've seen where the other person, like you would technically own the intellectual property, but you have very limited rights. When you own property of any kind, including intellectual property, you have a bundle of rights that come with it. We have an entire segment on that. But a lot of the times in these contracts, you give away a certain set of those rights. So if you make sure that it's clear that you have the right to use it, let's say for business purposes, such as marketing, then you have the right to it. But just on a very high level, you are the owner of the IP. Just what ownership rights you maintained is kind of up in the air. It's based on what you agree to. So correct me if I'm wrong, but you're probably wanting to use that content for promotional materials. And in those situations, I would encourage you to make that clear to your client.
Let's see, from Kenneth, he has a chat here. Can you make your invoice similar to a contract for payment and not hold you liable, etc.? The tow truck company tried to threaten a lien on my car that burned up, but they didn't pursue it.
Oh my God, that burn, but okay, so I have seen where you have a contract and it is mostly like an invoice. So it's very high level where it's like, here's an invoice for these services or for this car, so which would be a good, and this is how much you agree to pay, and here's how many cars you get, and here's when you get it by. Super high level. That would be enforceable so long as we have the elements that we talked about in the beginning, right? Offer, acceptance, consideration, and capacity to enter into something legally binding. If it's a good, of course, couple more requirements under the UCC. So it would be enforceable, but this is why we're doing this presentation today, to say that there's so much more to a contract that needs to be considered. For example, exactly what you say, a tow truck company tried to threaten a lien on my car that burnt up. This is something that we could have contemplated. It could have been in the form of liability waivers, limitation caps, or just, I don't think that would be force majeure, but just kind of what happens if something like that were to go wrong. So is it a contract? Probably is a contract. I would have encouraged you to make sure some more details would have been in there. Any other questions? These are really good questions.
We do have something from Toy. Okay, she wants this copy. Okay. She said, never mind. She provides an email address so we can answer her. So never mind.
Fantastic. LaShonda Stokes, what if a logo is created for your company professionally that you paid for? Does this explicitly mean your business owns the logo? It's kind of, I know this is going to sound so confusing. The person who created your logo is the original author of the logo. They have the copyright to it. They are the owner, unless they specifically say that they are going to give you all of their bundle of rights to that intellectual property. I really encourage you guys to check out our IP segment. It is by far my favorite topic. Lots of great visuals and examples because it is a very complicated topic. But when you're going to go copyright your logo, for example, or trademark your logo, there is going to be a section that asks for, the agreement that shows that if it was created for you, that it shows that you have the right to it. So technically, like, you do own it. That's the contract that you entered into. There's consideration, there's offer acceptance, mental capacity. We have those elements there. But under copyright law, for example, the person who created it is the owner.
We do, just an FYI, we do have another workshop with Gaia in 2 weeks on the 24th, devoted just to intellectual property. You should be receiving a digital announcement that you can register for it, just like you did this one. You should be seeing it here maybe this week. So
yes, please join. I would love to have you all there. Absolutely. Any other questions before I move on to NDAs? Let's see. Terry says, I have a similar question. So to hire a graphic designer, should I have a legal agreement with the designer that they do not have any legal rights to it? Or am I right, as it sounds like I do not have that right? Terry, you have the freedom to contract. Yes, you should have an agreement with your designer. If they don't give you one, I would encourage you to be the sophisticated business owner that you are and give them a contract. And this is where your IP provision comes to place. Specifically, I would look up work for hire clauses. Good questions. You're welcome. All right, folks, let's talk about NDAs. This is going to be super high level. I would love to do an entire workshop for you guys on these restrictive agreements or restrictive covenants, one being the NDA. But high level, let's talk about what it is. And please continue to drop your questions in the chat. After this, we will do a Q&A, so I'll be happy to answer all of them for you as well. All right. So a non-disclosure agreement, the purpose and use, it's essentially there to protect confidential and proprietary information for specific transactions and relationships. I see these most often in employment and independent contractor agreements, commercial transactions, like all of those we hear in the chat today would be commercial transactions, mergers and acquisitions, any finance and lending, and just complying with any existing confidential obligations. So that's typically where we see it, where, for example, I don't know if any of you are out for venture capital funds, but what you'll find is in some situations, they will bind you by an NDA where you cannot disclose the terms of that agreement. And the reason being is that they don't want you to shop around. Listen, when I was going to law school, when I was applying to law schools, I received several acceptance letters. And what I did was I leveraged that acceptance letter, because after all, it's a business. And I leveraged that letter to negotiate a better deal at the other law school. So at some point I had a scholarship, a laptop, some other amazing things. And I took that and went back and forth. They don't want you to do that. I understand. This is where an NDA would come in. Key provisions in an NDA are whether it's unilateral or mutual, meaning does the NDA, is it one-sided? Does it benefit just Terry's business, or does it benefit both people? When it's business to business, my rule of thumb is let's just make it mutual, unless one party has more bargaining power. If it's an enterprise and they're paying you hundreds of thousands a year, I'll make it one-sided, that's fine. You want to define what confidential information actually includes. It may not include everything. You might have, you might be okay with someone, disclosing your practice, just what you do that gives you the competitive edge because you disclose it and you're okay with it. But you don't want them to disclose your customer list or certain deals that you gave them that you haven't given someone else. So you want to define confidential information. The permitted Oh, I'm sorry, go ahead.
I was just going to say we have a chat from Kenneth that's in the news that Stormy Daniels is supposed to pay Trump some money because she broke her NDA.
Let me see that chat. Yeah, this is a huge deal right now. But the issue with that one, from what I understand, is not necessarily. Yeah, because she broke the NDA, but obviously there's a lot more legal implications beyond that, meaning specifically like why the NDA was there in the first place during that time. But exactly, NDAs can have some serious implications and they can be somewhat embarrassing as well. And actually, Kenneth, I think that's a really good point that you bring, because one thing that I haven't talked about here, but I would be talking about in a presentation specifically about restrictive covenants, is the fact that when someone breaches this, because it's possible, at the end of the day, when we talk about contracts and restrictive covenants, we're talking about something that we agreed to in writing, and whether people actually do it is it's kind of up in the air. When you do business with people, your intention is to know and trust them, but things go wrong. And so when you have an NDA and someone breaches it, it could affect your business nonetheless, okay? Because that information got out to the public. You cannot retract it. It's already out. But then you have rights to certain damages. You can recover your losses when traditionally you would not be able to. So it is important to have these type of covenants in your contract. Permitted uses, you might say you can have this, you can only disclose this information in certain situations. So you'd have that there. What happens when your contract is done with someone? You might have an NDA that requires the return or destruction of the confidential information. In a law firm instance, if you are my client, I have a whole file for you. I have all of your confidential information. But if we end our relationship as client and attorney, I will return or delete that file. So I don't no longer have access to it. You want to talk about the term of the NDA? How long does it last? And the survival period that we talked about. And then any additional restrictions that you can think about that would be necessary in your industry and in your business. The theme here is that as a business owner, you want to keep the competitive edge that you worked hard to build. And so we talk through that. You know, you really want to understand your business and not necessarily use a template form here, although templates are a good start. And last but not least is any compliance issues, retention policies for the confidentiality agreements, access to and use of the confidential information. In the IP segment, if you join, and I hope you will, we also talk about things like trade secret, which is heavily bound by contracts. You don't register trade secret with the United States Patent and Trademark Office or the Copyright Office. It's all contractual. So we talk about retention and actually how are you able to access that information, what you're required to do to keep it confidential and so on. So that would be what compliance issues refers to.
Hey, Gaia, is there a place they can go to get a template for this?
You know, Google is your best friend. You can always Google NDA templates and you'll find a ton on there. I will tell you, I've seen really good templates. I think what you would want to do is kind of go back through this presentation to make sure that they are legally binding and that you are considering everything you need to customize your templates. But I would say Google, also a lot of your local resources like SCORE or the SBA, Small Business Administration, things like that, you'll find good templates. And also, not to plug my business in, but GK Lawco will be selling templates as well soon, because I think there's a really big need for good templates. Besides that, I encourage you to also utilize resources like LegalZoom and Rocket Lawyer. Believe it or not, I think the difference is what you'll find is just not necessarily custom to your business. And so you do want to spend a little bit of time looking into it, okay? This is open for Q&A, which is good. I see some more chat, some more messages popping in there. Okay, let's see. Mike says, how should NDAs work when someone is pitching their idea or product at a pitch competition? Who should do the NDA? And Kenneth says, MK, you can do a penalty of death. You shall not disclose my pitch idea. I don't think you should do a penalty of death. This is a great question. Fantastic question. I actually work with clients on this all the time who are pitching their idea. It depends, right? Traditionally, you want the organization to enter into the NDA, and any of the attendees there, the idea is that they understand that everything is confidential. And so typically you want to put more of your trust into the organization and how they're relaying the fact that this is going to be confidential. If you have something that is super proprietary, let's say it's patentable, and if it's patentable, you definitely do not want to publicly disclose it, or you will lose your ability to patent it. In those situations, I encourage you to make sure your audience is much smaller and that only select few are getting the opportunity to hear your pitch. However, in practice, what I found is a lot of these organizations will not sign an NDA. So there are some risks involved as someone who's pitching for funding, where sometimes, like I said, you have to assess your comfort with risk when you're disclosing ideas. But to answer your question, I would usually go to the organizers. All right. Terry asks, what are your thoughts on using artificial intelligence to write a contract without someone like you? I was just talking to Gwen and Ed about artificial intelligence. I've tested ChatGPT, for example, and I'm a fan of AI. I use AI in my law firm regularly. But what I found is it's not quite advanced enough yet. I've asked it to write licensing agreements, to write service agreements for me, and it's not quite there. It gives you something very short very high level and very generic. So I would not necessarily trust it. I think I would put it close to, maybe if I had to prioritize, it would be your attorney, LegalZoom, Rocket Lawyer, those type of platforms, and then artificial intelligence is just not quite there yet. It's not that good. You're going to be missing a lot of the custom things that you want and a lot of the protective provisions that we talked about. What you could do though, to save some money, is you can get a template, or you can ask, ChatGPT to help you out with a template, and then you can have your attorney review it. That's definitely an option as well. All right, any other questions? You're welcome, Amber. Thank you for staying through this presentation. All right, I know we have, I think we're over on time. Let me add this screen here for you guys. I just wanted to take the time again and say thank you so much for attending and taking the first step towards mastering contract writing and review. I'm so proud of you. A lot of the time people do not take this time to be great business owners, and you're all here today. So thank you for showing up. As a big thank you, I'm going to send you all a free service agreement template that you can use. Of course, you'll need to customize it. You'll see it's highlighted in yellow what you need to change, so it's specific to your business. But I think it'll be a fun practice for you to go through and kind of see those provisions we're talking about, because you'll see those in that agreement template. And I just want to wish you the best of luck. And I don't know why, but happy contracting. Let me see. There's some other questions I see.
Okay, Gaia, thank you so much for your time. I thought it was fairly interactive, which is really good. I just want to remind everybody that on the 24th of this month at 11 a.m., Gaia will be presenting again IP, which is a pretty big topic these days. So with that, I'll thank you for participating, and have a great day. So long.
Bye, everyone. Thank you for your kind words. Take care.